Hi, welcome back to Frequently Asked Fridays, where we here at Martin IP Law Group answer your questions about intellectual property matters. Today, I'm actually going to answer an IP related question that I got from someone on Facebook Messenger earlier this week. The question essentially was, what intellectual property can I use to cover an app that I've developed? Or, as I like to refer to it, how do I cover my app? So from an IP perspective, really there are three areas of IP that could apply to an app: patents, trademarks, or copyrights. All three could apply and would protect an app that was developed by someone. So let's dig into that a little bit here. Patents. If your app meets the requirement for patentability, you could obtain a patent on that. And again, the three requirements for patentability are it has to be useful, it has to be novel, and it has to be non-obvious. You can look at some of our other videos that cover those topics in a little more detail, but essentially if your app performs a function that meets those three standards, you can get a utility patent for your app for the function that it provides. Second, let's look at trademarks. So trademarks, again, are your branding. So trademarks can cover the name of your app, the symbols that you use associated with your app, taglines, slogans, logos, anything that you use to identify the source of your app can be trademarked and is protectable intellectual property that you should consider protecting in connection with your app. Lastly, copyrights. Copyrights are going to protect the creative expression. So probably at least two things that can be protected with copyright with regard to an app. One would be sort of the icon or logo or the creative design that you're going to use to get people to buy your app. So your app's going to have an icon with it. Whatever design you put together with that is protectable by copyright. Also, the source code, the software that you develop your app, that the app is written to cover, that's protectable by copyright law as well. Again, with copyrights, the protection attaches upon creation of the work, but registration of that copyright, of the source code, of the logo, of the artwork is going to provide you additional benefits. One, the ability to sue if someone infringes it, and two, enhanced damages if you're successful in suing that may not be available under common law. Similar with trademarks, trademark is going to apply once the mark is used in commerce. However, federal registration gives you that coverage across all 50 states, plus also provides you some enhanced damages and benefits that aren't available under common law. So that's how you cover your app. I hope that's been helpful, and I hope you have a great weekend. Thanks for tuning in.